in the name of personal injury law.
Today I have with me Steve Sinas of the Sinas Law Firm, and he has two very special guests with him today. Steve, can you tell us who these people are?
Yeah, well, today we're going to talk about police misconduct cases and how those are handled in civil litigation. And there's, a whole lot of misinformation about what goes on with these cases. So I'm happy to have with me Cindy Heenan and Buck Davis from the law firm of the Constitutional Litigation Associates. They're located in downtown Detroit, and we've actually co-counseled a couple police misconduct cases with them, and we're going to talk to the viewers about that today.
So tell us about the law for police misconduct cases.
Yes, the primary statute is 42 United States Code 1983, and that's why it's called 1983 litigation. It's an interesting statute. It's the first civil rights statute ever passed in the United States. It's the Civil Rights Act of 1871, originally known as the Ku Klux Klan Act, because after the Civil War and the Union troops were removed, the Southern aristocracy drummed up the Klan to try to force the minorities and poor whites back into semi-servitude. And so this original statute was aimed at suppressing the Klan. The second thing that's important about it is that it's the only civil rights statute which applies to everybody. It's not based on race or religion or national origin. It's to assert federal control over every local and state official to enforce the Constitution, primarily the Bill of Rights, First Amendment, Fourth Amendment, and 14th Amendment. And so it wasn't used much for almost 100 years, and then it became popular during the civil rights movement that started in the 50s and the 60s down south and has now grown into a subspecialty in the law.
And within the law, it allows people to pursue damages if the government has violated their constitutional rights.
Right. And the Fourth Amendment is the constitutional provision that we're looking to when we talk about these cases, police misconduct cases. The Fourth Amendment protects citizens against unreasonable searches and seizures of their persons, their homes, their papers, and their effects. And in this context, the seizure, we're talking about seizures in most cases. An arrest is a seizure. Being shot by a police officer with a gun or a taser is a seizure. Being grabbed and thrown to the ground or pulled out of your vehicle is a seizure. Or even being told to just stay where you are, but that you are not free to leave, is a seizure. And of course, not all force or all seizures are unreasonable. In this litigation, it's the reasonableness or lack of reasonableness that's the key.
Yeah.
So I understand that you worked on some significant cases with the Sinas Law Firm, and I would really want to hear more about those two cases, the Bletz case and the Guilford case.
Yeah, so and I want to first say I have the utmost respect and admiration for police officers and know that the vast majority of them are doing great work and they should be commended for serving our communities in the way they do. However, police officers even tell me that they're happy that this law exists, that there's a way for accountability to exist if constitutional rights are being violated by other police officers. So as far as these two cases go, these were unfortunate, tragic situations involving fatalities. And here is the basic facts of the Bletz case. Mr. Bletz's son had a drunk driving charge, and the police came up to their house, and the son still lived with them at 12 a.m. in the morning, or at midnight, and went to serve a bench warrant on the son. And Mr. Bletz woke up because of all the commotion around the front porch with the dogs barking, and grabbed his handgun and walked down the hall in his underwear. And one of the cops who was standing in the doorway got scared by his presence and shot him, just really within a matter of seconds. And the other cop really didn't justify the other officer's actions. In fact, he kind of waffled in his deposition about whether he thought that was really a reasonable use of force. And obviously the argument is that this poor man who just got up out of his sleep using a lawfully owned firearm shouldn't have been shot in his underwear in his hallway. And then he bled to death in his house. They locked up the wife in the car while he was bleeding. It was just a horrible situation. So, Buck can tell us a little bit more about how that case was actually handled in the courts. Our firm worked hand in hand with their firm. And Buck, why don't you tell a little bit more about that?
You can file a civil rights case in either state court or federal court, but we always file in federal court. Otherwise, you're dealing with a jury from the same jurisdiction as the police that you're suing. And so we think you get a fairer shot at it in federal court. In 1985, the Supreme Court, the government does not like being sued, and therefore they erect every possible barrier. And the Supreme Court decided a doctrine called qualified immunity. That is, unless it was absolutely clear that the action that the officer was undertaking was unconstitutional or illegal, he's entitled to immunity. And then they decided that if the officer filed for qualified immunity and was denied, they could take an interlocutory appeal before trial, because immunity is immunity from suit, not just immunity from trial, which means that almost every case goes to the Sixth Circuit Court of Appeals in Cincinnati. The computer shows I've been there 140 times since 1990. And it means that these cases string out between 3 and 5 years. You have to stand there a long time in order to get to the end, which is one of the reasons that not many people specialize in this particular area of the law.
So in the Bletz case, you had to go to the Sixth Circuit in the middle of the case.
Yes.
And basically earn the right to finalize the case.
Right.
And I think it's settled. You know, before we run out of time, I want to make sure we talk about the Guilford case.
Yeah, so Bletz came back to the trial court after the opinion, and then it settled because they didn't want to face the trial. The Guilford case, similar thing happened in terms of the legal result. It settled while the case was actually pending appeal on the qualified immunity. But what happened with Devin Guilford is that he was driving down a road and he flashed a police officer with his bright lights, thinking the officer had his bright lights on. The officer pulled him over for doing that, and then they had a verbal altercation with one another. It's fair to say that Devin was not really complying with the officer verbally, but it resulted in the officer removing him from the car, putting him down on the road, then tasing him. And then the issue that came up in the case is what happened after he was tased. The officer said Devin charged him, and then the officer then shot him 7 times. And there was discrepancies enough for the case to settle prior to trial. And that's
very tragic cases.
Yeah.
Thank you for sharing them with us today.
Thank you.
In the Name of Personal Injury Law is brought to you by the Sinas Law Firm. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes.